Hello and welcome to the Coalition of Franchisee Associations webinar focusing on protecting your business from encroachment and cannibalization. Before we begin, please note all participants have been placed on mute with video off to help keep background noise to a minimum. If you are dialing in via phone, you may experience a 1 to 2 second lag during the meeting. You may submit questions you have throughout the meeting by typing them into the questions box on the right-hand side of your screen. Your questions will be addressed as time permits at the end of the webinar. Joining us now is Misty Challey, Executive Director of the CFA.
Thank you, Sean, and thank you to everyone registered for today's webinar series. Today's webinar focuses on encroachment and cannibalization in franchising. Note that this information is provided as a benefit of membership in the Coalition of Franchisee Associations, the country's largest franchisee-only trade association. Together, CFA members represent over 45,000 franchisees, employing over 1.5 million individuals. For many of you, our guest speaker needs no introduction, but for those of you that don't know him, Robert Zarco is a renowned advocate for franchisees in all aspects of franchise law. As the founder and senior partner of Zarco, Einhorn, Salkowski, and Brito, he's been at the forefront of protecting legal rights in both in and out of the courtroom, repeatedly receiving awards including Lawyer of the Year, Top Deal Makers of the Year, Legal Eagle, and one of Florida's super lawyers. Robert's firm just celebrated its 30th anniversary in what was arguably the party of the century. Without further ado, please welcome Robert Zarco.
Good afternoon. Thank you so much, Misty and Sean, for your kind introduction. I'm blushing a little bit because I try to remain as modest as I can. However, I love doing what I do. And in the world of franchise law, one of the dearest subjects that I like to talk about is the concept of encroachment and cannibalization, which arises when a franchisor places a competing unit in close proximity to an existing unit or undertakes other types of activities or actions within the franchise relationship that serves to impact the sales of the existing franchise unit. The doctrine of the implied covenant of good faith and fair dealing, many of you have heard about. I'm going to explain that and how it dovetails into the encroachment and cannibalization claims. But I think it's appropriate that I give you just very quick background as to who I am and why it is that I am considered an authority on this subject by the media, by state legislatures, by courts as an expert in this area of law. I've been doing franchising, practicing franchise law for over 35 years. We probably have the largest or among the largest franchise practice in the world, representing franchisees from over 500 different brands in 23 countries and 44 states. I have learned how to spell franchising as a result of the vast experience and knowledge that I have in this area. Our law firm has been very involved and has been responsible for many of the precedent-setting cases in the world of franchising. And it's a subject that's very dear to my heart because when I was a kid, every time I would drive by a McDonald's or Burger King and I would see, lines out the door, I was like, wow, this is great. One day I want to own a franchise and be a rich person. And then many years later, I start practicing law, and a franchise case comes across my desk, and I learned that the reality of franchising in America is not always what it's perceived to be. So that, together with my educational background, I have a degree in economics from Harvard. I have 95% of an MBA in finance and accounting from a business school, and also have worked for General Motors in finance and accounting for a number of years before I became a lawyer. And all of those background aspects of my experience roll together in being able to truly understand cannibalization and encroachment and how it affects the franchisee. So as I stated, what is encroachment? What is cannibalization? The whole purpose behind it is a transfer of sales, where sales are transferred from one location to another location that's competing with the existing location. Typically, it's competing within the same brand. You can have it where you have one restaurant open at your address, and then the franchisor places an exact same type of restaurant, same brand, but newer, brighter, shinier, with the current image, you know, a mile away or 3 miles away, or at a distance where the new restaurant is going to, in essence, interfere with your restaurant's ability to gain and service those particular customers. That's one way. Another way is where your nearby franchisee is providing delivery services into the market which you relied on heavily to support your business and generate sales. And those situations can have a very deleterious effect on your franchise business, and that is also considered cannibalization and encroachment. You can have marketing, cross-marketing, where a franchisor or a franchisee markets another franchisee's business into your territory, or vice versa. That is a form of encroachment and cannibalization. Over the years, franchisors have tried to grow and expand their businesses in order to increase revenues. Let's face it, the franchisors own the brand, they own the system, but what they really need is substantial increase in net income. Every business wants to make more money. So in the world of franchising, the way that's done is by increasing gross revenues. How do you increase gross revenues? Well, the franchisor gets typically 5, 6, 7%, whatever the agreement that you have with the franchisor dictates, of the gross revenue as a royalty. That's in addition to what the franchisor may get in terms of marketing fees or other fees. Marketing fees can be 2, 3, 4% of gross revenues. So the franchisor is incentivized to increase the gross revenues generated in the system overall, because the higher the gross revenue base, the higher the amount of royalties and marketing that the franchisor can generate for itself. In franchising, it's net income, and it's in marketing to be able to promote the brand. What has happened over the years is once franchisors realize that over-encroachment or oversaturation of a particular market, may be met with a lot of challenges, the franchisor has developed alternative forms of distribution of the business, what we call alternative distribution channels. And many of you have seen, are familiar, where supermarkets are now selling the product that you sell out of your franchise, or product is being sold on the internet. Yes, including ice cream. We know that Carvel sells ice cream over the internet and is delivered with dry ice. You have internet sales like this that abound in many other different kinds of industries. You have home delivery, where the franchisor may ship to the home or may have a delivery service that it contracts with. You have sales through eBay, you have Twitter, you have Facebook, you have drive-throughs that are now being offered in businesses that perhaps in the past, those businesses did not have drive-throughs, and therefore those units now become competitive to your unit that was not built or designed with a drive-through. The situation has become much more complex than in the past, because we all know that there is an inherent conflict of interest between the franchisor's desires and the franchisee's desires. The franchisor wants to increase its profitability, and the franchisee wants to increase their individual profitability. The problem is that sometimes what happens is that as a result, you have a competing wave. For instance, if the franchisor is going to increase their revenue by taking action that negatively impacts the franchisee's net income, then you have a clear conflicting interest. Matters have gotten worse, and I have seen, I predicted it about 4 or 5 years ago, that it was going to get worse once private equity came on board. Unlike a franchisor that may have developed a particular concept which it considers its baby, or another franchisor that's in the same industry but buys a company that has the same kind of product line and is attached to the type of business or to the concept, private equity has a whole different ballgame in mind. Their incentives and motivation are very different. They don't really care whether they like the food business, the hotel business, the oil change business, the esthetician business, cosmetics. They don't care. The investment in private equity is based exclusively on dollars invested versus dollars returned. And because private equity, when they come into an investment, already has a planned exit strategy, meaning they're going to come in, buy into the business, and within 3 to 5 years, they are going to then undertake an exit strategy to sell it. They have to maximize the amount of money they put in. They maximize the amount of money I got distracted by something, I'm sorry. They maximize the amount of money they put in to see how that can generate the greatest level of return. So what they do is, if they can bump up revenues, those revenues to them will increase their net income. And if their net income goes up by, let's say, $1 million, which, while you may think is a lot of money, it's not a lot of money in a private equity type investment. And these businesses are sold on multiples on Wall Street, where the price is a multiple of the net income. So it's 5 times, 7 times. I know businesses that are selling it 14 times, 15 times multiple. That means that when the net income goes up by 1 million, the market value, the price of that company, the value of that company has gone up by $15 million. So you can imagine the extraordinary motivation and incentive that the franchisor has through private equity, which now controls them, in increasing revenue. So now you're going to see as another method of encroaching on a franchisee sale is where the franchisor is setting up what's called ghost kitchens. And ghost kitchens are locations where the franchisor will go to a parking lot, like let's say Reef. There's a company called Reef, R-E-E-F, that owns a lot of parking lots, around the country. And they are now subleasing space in the corner of their parking lots for a franchisor to take an 18-wheeler or even a 25-foot truck, if you may, or build like a trailer and start producing food product of that brand in that location. And what they then do is they sell out of that location to people that want catering events or to walk up customers. You have an overnight business competing with your business, which costs $100,000, $120,000 to set up. Meanwhile, your brick and mortar or your inline store is going to cost you $600,000 to $1 million or $1.2 million or $1.5 million to set up. That can be devastating to an existing franchisee. The other method is a food truck. The food truck is even worse. A food truck is going to rove around town and find what is the next major festival, carnival, music event, sporting event that they can park their truck right outside. And meanwhile, your store is a block away, half a block away from the arena, but they're going to go ahead and put this food truck right on the foot of the entry or exit of that business, of that event, of that sporting event. And they're going to cut a lot into your sales. So how is it that a franchisee can be protected? First and foremost, whenever you're going to buy into a franchise, always factor in that whatever the sales are of the business you are buying, if it's already in existence, or if there's one that has projections on it that are reliable, always factor in a 10 to 15% impact on your revenue. You need to do that because it is likely, or at least very possible, that it will occur. Encroachment is where you add more stores and it has an impact on your sales. But there's something that's also called reverse encroachment or decroachment, which is the shrinking of the brand. Sometimes because of whatever circumstances, two locations near to each other are not doing well. They are both failing. And the franchisor will decroach or shrink the market by forcing one of you two out. And when one of you is forced out, your lost sales get transferred to the other location, at which point those restaurants' revenues are bolstered and that franchisee can survive, but you become the victim. You have to be very, very careful that that happens. The document that governs encroachment is the franchise agreement. That's a document that deals with whether or not you in fact have territorial rights or you do not. Typically, it's contained in item 12 of the franchise disclosure document. And that's where typically there's a discussion as to whether or not there is exclusivity or there is not exclusivity. Exclusivity in your franchise agreement is a crucial element of your franchise transaction. You must read the provision very carefully. But what people in the past thought was language that provided you with exclusive territory does not work these days, because you may have a provision that says we have a 5-mile radius protection. You go like, wow, 5 miles, I'm great, I'm protected. Nobody's going to be, within 5 miles, except you need to understand what that 5 miles really means. Is it 5 miles as the crow flies? Is it 5 miles driving distance? You need to know whether it's radius or whether it's as the crow flies. I'd like typically, if there's an exclusive territory, that there be a map attached to the franchise agreement, which shows either a ring, which has a detailed map so you know where it is, or if it is an area that is set forth by whether it be zip codes, whether it be boundaries, whether it be population, or whether it be any other kind of clear demarcation. You need to do that because territorial protection comes in very many different ways. Now, when you read the exclusivity provision, you must focus on what is the most important provision in the agreement, and that's called the Reservation of Rights Clause. It may not be written where the caption title says Reservation of Rights. It'll simply be embedded within the language of the agreement, which is truly the most dangerous provision for you. And the Reservation of Rights provision is the one that says, yes, you have 5-mile radius. However, the airports are allowed to be developed by us. We have the right to develop, and you acknowledge and give us the right to do so, regardless of how much it will impact your sales, income, or profitability. You allow us to have the right for us to operate or to give the rights to someone else to operate a location in the airport, in schools, in universities, in bus stations, in highway service plazas, and things of that sort. I can tell you, I have seen many, many cases where franchisees are financially decimated that have 5-mile exclusive territorial protections, and yet within a mile or half a mile of their business, there is a competing location built by the franchisor or awarded to another franchisee by the franchisor, which eviscerates the franchisee. Now, there are different types of encroachment. You have the internal franchisor, which is the typical encroachment, which is where the franchisor, you own a Burger King and the franchisor, Burger King, puts another Burger King. That's your typical one. But what also happens now, and this is happening with the onslaught of private equity even more than before, because of the vast amount of money that's available, is where the franchisor acquires a competing brand within the same industry selling the same type of product. At that point, that has a whole multitude of problems and issues which arise. For instance, if you have a franchisor that buys another burger business or another hotel business or buys another furniture moving business, which was previously their competitor, and a new idea comes up as how to grow and expand the business in this industry, well, who gets it? Is the new idea, the new marketing concept and marketing, monies that are going to be invested going to go to the new brand? Is it going to go to the old brand? Is the franchisor buying that brand because they want their real estate locations and they're going to convert the old locations into your brand? And what about if you were competing with someone that was 2 blocks away, or in many situations I've seen across the street, and the franchisor requires everyone to convert to your brand, and now you have a store literally, and I have seen this, 60 feet away from your store with the same brand? Imagine a 7-Eleven that is 60 feet away from another 7-Eleven. Now you must think I'm crazy. No, we had the case. Yes, of course we won the case. But the point is these things happen because the franchisors thinks that they can get away with a lot of these things. But you have to understand that these factors are substantial. They're significant and could have a substantial impact on you in terms of how it affects your business. Marketing, cross-marketing issues are really a big problem. Now, these encroachment acts by the franchisor can trigger contractual breaches. And the success that you may have on those contractual breaches depends on the clarity and non-ambiguity of the language in your contract. Because there is a merger and integration clause in these agreements, meaning a provision in the back of the agreement that says that you are to rely only as to the language in the agreement and not on anything else, whatever promises or representations were made to you by the franchisor as to what they would or would not do, regardless of what the agreement says, you cannot and should not rely upon it. In fact, if it's in writing before you sign the franchise agreement and that writing is not incorporated in your contract as an exhibit, don't rely on it, because as a matter of law, it's deemed to be unreasonable reliance, even if signed by the president of the company, unless it is attached to your franchise agreement. You're also going to hear about policies, encroachment policies. Don't worry about it if you're going to get encroached or you feel you're being encroached. We have an encroachment policy that says that if your sales have been impacted more than 5% or 7% or 3%, whatever the particular encroachment policy is, we will do a calculation and go ahead and determine how much you've impacted, and then we'll pay you a percentage of that. So franchisor encroaches upon you, you say, hey, look what the policy says. They say, well, we're not going to enforce the policy here. And so you sue under a breach of the policy. Well, there's a whole slew of case law that specifically says that the policy is not part of the agreement unless it is specifically attached to as an exhibit. You have to make sure that when you have a situation where there is an acquisition of one competing brand to your brand, okay, and again, this happens in hotels, food service, service industries, you have to make sure you inquire immediately as to how it's going to impact you. For instance, if you're in the hotel business, how is that going to impact the points reward program? Is the points obtained at one brand that was previously a competing brand going to be redeemable in your brand? And I have seen that happen. Well, that becomes a problem or not a problem. In some cases, it's beneficial. In some cases, it's really problematic. If you have a food service business, for instance, Dunkin' Donuts merged with Baskin Robbins. which then merged with Togo's. And instead of having combo locations, at one point you have what we call trombos, where a consumer goes to buy a donut, but decides that he's got Baskin Robbins, so now he's not going to buy from Dunkin', is going to buy from Baskin, or says, you know what, I was going to buy a donut, then I decided for an ice cream, but now I see I got a sandwich, so let me go buy a sandwich from the Togo's sandwich. All those issues have to be laid out. The manner in which they service, the service, support, and assistance that is going to be provided to your brand versus the other brand is very, very important to consider. The issue, again, with the impact policies, they arise, one, through encroachment, two, if there's rebuilding or replacing old units. If the franchisor has an existing location and they go ahead and they build a brand new location, naturally the consumer is going to want the bigger, better, more beautiful location, and that's going to impact you. So what advice can I give to you in situations like this? I've been giving speeches on franchising for over 30 years. You'd be surprised how many people have heard me speak and still don't do what I say. And then they come into my office and say, but I thought you were at that conference and I told you to do this. Yeah, but I was afraid to put it in writing because then they would think I was being, too legal. I said, not with my name. You don't have to put my name. You put your name. You write a letter, and document these things. If you do not object immediately, the minute you get a whiff of the fact that there is a store or some other competitive cannibalization type of action taken by the franchisor, it will be deemed by a court that you acquiesced or agreed or were okay with it, or that you waived your right to it because you had the opportunity to put it in writing. Telling someone is not enough. People either have short memories or they have no integrity. You'd be surprised how many presidents, vice presidents, senior directors, and officers of companies lie under oath. You'd be surprised how many franchisees lie to their lawyer, not only to the court. This is very important that you document it. And if you don't know how to document it, which most of you truly will not know, then you call a lawyer and you ask them to ghost write the letter for you. I do a lot of ghost writing because I don't want the franchisor to know that my client is armed with a lawyer just yet. Franchisee comes to me, I ghost write a letter, and I say, dear, licensing director or franchise director, it's just come to my attention. It has come to my attention that a competing location is being considered for this store on a block away from mine. I object to that store. It will have a devastating impact on me, and other language that I would put in there. You then send the letter, you sign it. It will not be written in a legal format or look like legalese. It'll be plain, simple English in the manner that I'm speaking to now, at which point now you put the franchisor on notice. And when that happens, now the franchisor has to think twice. Wow, now it is documented that this is going to happen. Then you have to see how the franchisor wants to deal with it. If the franchisor says, you know what, let's go ahead and bring it to the impact committee or to the ombudsman and see how we handle that, then you got to immediately find out what the deadlines and procedures are. Because if you have an impact or encroachment situation, there are procedures that may be laid out in the franchise agreement or in the ombudsman or impact policies that say you have to file your complaint or your objection, which within this particular period of time. And if you do not do that, your complaint will be deemed to have been waived. You need to make sure that that is done. Next, the person who is going to determine whether or not there is a proper claim for you or that you should be compensated should not be the franchisor's ombudsman. It should not be the franchisor's neutral paid for by the franchisor. Because guess what? You're going to be loyal to the person that feeds you. So the neutral third party that is going to look at this should be an independent mediator to be paid jointly by the franchisor and the franchisee. And there should be some kind of formula that if it is found that if the neutral determines that there is proper encroachment, then the franchisor pays the neutral at the end, or in other words, reimburses the franchisee, and vice versa. If the neutral finds that the franchisor is doing nothing wrong and that it's reasonable and that you have failed to provide evidence that would reflect that you are impacted, then that's the case. One of the most important things to do is to ask the franchisor in writing, what is the business case? What is the basis for you to have selected this location? What studies have you done? Did you do a market study? Did you do a demographic study? And when you did that, what were the results? This happens also when a franchisor tells you that he wants you to rebuild or remodel your store in order to keep up with brand image, and you realize that you have a store that's generating, $300,000-$400,000 of revenue, and the franchisor wants you to put $500,000 in. You're never going to be able to collect a reasonable return on investment for that. As a result, you need to ask the franchisor, tell me what studies you have, what have you undertaken in terms of what justifies you making this particular request. Now, the law is very clear, assuming a provision is written very clear. For instance, if there's a provision that says that any and all, the franchisee acknowledges that the franchisor is permitted to build any location at any site that it deems appropriate, regardless of how close or how far it is to the existing franchisee's location, or what the level of impact it will have on the franchisee's costs, brand goodwill, reputation of the business, profits, income, revenue, and all that reservation of rights language is in the contract. And the franchisor then proceeds to do so. The implied covenant of good faith and fair dealing does not serve to protect a franchisor from agreed upon express contractual provisions. That is common case law that has been developed over the years. The doctrine of the implied covenant of good faith and fair dealing in the world of franchising, as it was developed on franchise encroachment issues, was developed by me and my firm in early 1990s, late 1987, 88, in a big case called Sheck versus Burger King. That is the seminal case on the issue of the implied covenant of good faith and fair dealing. And in that case, in fact, the federal judge here in South Florida, found that the franchisor could not put a store wherever it wanted without, which would deprive the franchisee of receiving the benefits of the contract. So let me explain the implied covenant real quickly. The contracts you sign are bilateral. There's two parties. You're a franchisee, they're the franchisor, and you both have a duty to act in good faith with each other, unless you're in the state of Texas, which does not recognize the implied covenant of good faith and fair dealing, surprisingly. But what happens is, you as the franchisee cannot do anything that impairs or interferes the franchisor's ability to run and operate its business. Likewise, the franchisor cannot act in a way that will impede your ability or interfere with your ability to earn the fruits of the contract. And in that case, the court found that, in fact, the franchisor could not do that. However, the court said that had the franchisor specifically stated in the agreement, and the franchisee signed that agreement, acknowledging that the franchisor had the right to do it, the implied covenant of good faith and fair dealing would not apply. So you have what's called common law, that principles, which is the applied covenant of good faith and fair dealing. And then you have statutory laws. Some states have statutes that preclude a franchisor from competing unfairly with a franchisee. Other states don't. For instance, the Iowa Franchise Act has an anti-encroachment provisions. Other states do as well. There are claims for tortious interference when the franchisor buys another location, another brand. There's a tortious interference that the franchisee can file against the new brand coming in because it's interfering with your brand. And I'm not going to get into legal arguments here because that's beyond the scope of what I'm here to do today. There's also some states that find that an improper or unfair level of impact and encroachment could rise to the level of an unfair and deceptive trade practice. And there are in the unfair deceptive trade practice is what's called the Little FTC Act. For those of you who may not know, the Federal Trade Commission, which regulates franchising, does not have what's called a private right of action, meaning you as an individual franchisee cannot sue a franchisor for having violated the Federal Trade Commission rules for Statute 436. However, most states in this country have what's called little FTC acts, and they're called Unfair Deceptive Trade Practice Acts. And what those acts do is it gives a franchisee who has become a victim or has sustained losses as a result of these unfair practices to sue under those statutes, which statutes consider that a violation of the FTC Act is deemed to be a violation of this little FTC Act called the Unfair Deceptive Trade Practices in the state, therefore giving the franchisee remedy and relief. You have also in some states non-competition statutes. These we use occasionally when available and when the language is appropriate, which says that if you are unfairly competing with someone, which you can show as a matter of numbers, income impact, where your revenues are down, or whatever other source of competition is being utilized that hurts your business. In many states, there are non-competition statutes, like let's say California, where you can rely on those. Some states have franchise relationship acts as opposed to franchise sales acts. There are many states have franchise sales acts. For instance, what the law should be that governs the representations and the responsibilities of the franchisor to the franchisee at the time that the franchisee is going to enter the relationship. This statute only applies up until the time you sign the franchise agreement. Then you have to depend on what's called a Franchise Relationship Act, which kicks in after the franchise agreement is signed. So there's a difference. You have the statute that governs from the moment you start thinking about franchising, buying a franchise business, until you sign it, the franchise agreement. And whatever the franchisor does or does not do, or you do, you do not do, that's governed by one statute. It's like an initial investment law. But once you sign the franchise agreement, a new statute kicks in, which is the relationship statute. Not all states have it. Like I said, some states do, some states don't. There are more and more of these franchise relationship statutes that are being formed, but we're trying to get these kind of statutes developed at a national level. One of the participants here that's viewing is my good friend Keith Miller, who does a fantastic job in promoting fair franchising laws, is running himself crazy through Washington, D.C., talking to congressmen and senators on trying to get fair franchising bills out there for the benefit of all franchisees in the country through a national law that affects everyone and benefits the franchisees fairly. If you're a dealer, if you're a dealer of a business, as opposed to a franchisee, there are dealership acts and dealership laws in different states. You have motor vehicle dealership laws, You have, which govern the purchasing, the sale of dealerships, which also govern how far one dealership is from another dealership, what points, meaning what dealer points, dealer locations can be offered or not offered, and things of that sort. So again, the purpose of this webinar was to advise you, first of all, what the current status of encroachment is. Again, like I said, what you have to look out for is that because of the onslaught of private equity, where private equity is incentivized, it's the crux of their business to grow revenue, and they invest in a franchise company, rest assured, they are going to be developing and expanding their business in a way that's going to impact you. One thing that, as an example, which is so, I think, such a blatant breach of a franchisee's agreement and a blatant breach of the law, is there are certain franchise companies now that are owned by private equity. And I'm not going to say the name because it's not important. If you own 5 ABC stores and you want to sell those 5 stores, the franchisor says you're only permitted to sell them to someone who will buy your 5 stores and agree to develop 5 more. There are some that are saying, I will only allow you to sell the 5 stores if the buyer agrees to invest and develop 10 stores more. Now, let me tell you something. That's crazy, because what that does is it strips and wipes your equity. Because if your stores were worth, for round numbers, $5 million, and the franchise and the prospective buyer says, I'm going to put $5 million in this business, and the franchisee amasses a pool of people to generate this amount of funds to buy $5 million to get into the business. And now they're told, well, it's not just the $5 million, you see, you got to build 5 more. So that prospective buyer now needs 10 million. But it's not so easy to get more and more money. You can't assume that somebody who put together 5 million can put together 10. So the franchisee will say, wait a second. If I've got to go ahead and to buy these 5, I'm required to build 5 more. Hey, existing franchisee, I'm only going to give you 3.5 million because I need now 5 million to build the new stores. So you, in essence, as the seller of those franchises, are going to be subsidizing the purchase of the new prospective franchisee because they need the money to be able to commit to the future development. These provisions I have not seen in the agreement, but I have seen franchisor impose that on franchisees, and many franchisees think that because the policy, the company policy now says it, or the operations manual now says it, that they have to do it. And that is not true. There are certain things that are governed only by contract. There are certain things that are governed by policy. So the franchisor says, listen, instead of putting 2 slices of pickles, I want you to put 3. That's a policy issue. That's an operations manual issue. There's nothing wrong with that. But if the franchisor says, I want you to start now selling hot dogs when you are in the hamburger business, or now I want you to start, selling cars or selling, headlights, or doing something that is outside the fundamental concept of the business you invested in, that would be inappropriate. So, because I have at least 15 minutes left, I can take as much time as you want. I'm here available to answer any questions you can have on this issue or any other issue in franchising. I would like for you to try to keep it as issues that are systemic in nature, as opposed to your particular store. Don't tell me about a store that you had that had a roach problem, because I would have to take that offline and deal with you on an individual basis. But if you have a situation where your franchisor has now implemented a new program, a new policy, is undertaking a redevelopment plan that has been grossly impacting the sales of your business and those of other franchisees in your brand, or the franchisor is looking to merge, those are the kinds of questions that I would like to entertain today. But I appreciate having had the time to give you a brief overview of the world of the law in franchising as it pertains to encroachment and cannibalization, and how, as important as it was in the past, it is now much more important for you to consider, again, to be repetitive, because it is that important. The onslaught of private equity coming in is their model is to grow aggressively. They have to do so within 3 to 5 years so they can get out, and they can get their high returns for their investors. Thank you.
All right, thank you, Robert. We have a couple questions here. First, someone says, thank you for doing this. What about other brands owned by the franchisor? For example, for Burger King, what if they put a Firehouse Subs next to a Burger King? Both brands compete for the same lunch traffic. What chance does an existing franchisee have to stop that?
Okay, there you're going to immediately have what we call the transfer of sales. If I was going to have a desire to go to a Burger King to get a Whopper, and my wife says to me, you don't need a Whopper because it's got 1,000 calories in it. Why don't we go to the Firehouse Subs that have more healthy sandwiches and it's only 400? Guess what? If the Fire Subs was not there, I'd probably end up having my Whopper. So clearly you have a level of transfer of sales. Now, what is the level? Is it going to be, are your sales going to go down 3%, 2%, or 20%? It is the claim for encroachment and cannibalization becomes thinner and weaker the greater the disparity is between the brand you currently have and the encroaching brand. The fact that it is owned by the same franchisor gives you a lot more evidence of impact and encroachment, not necessarily maybe directly on transfer of sales, but in terms of marketing dollars, management overseeing, management oversight, allocation of service and support resources, allocation of marketing and support resources, allocation of new marketing programs, and to who they're going to be given, to Firehouse Subs or to Burger King, because the new marketing idea is targeting the lunch business, let's say. So at that point, you have to see how much of an impact it's really going to create and have on your business. Now, zero impact is not the standard. 1%, 2% impact is not the standard. 3%, I think, is when it starts getting interesting. And 5% is when it starts becoming more significant. Why? Because when you joined the business and you entered as a franchisee, you knew you were not going to be making independent decisions. You knew you were one of many, and one of many more to come. So unless your store is in Florida and your competing unit is opened up in California, unless you can establish that that California resident travels only to Miami, okay, and is not going to have your burger in Miami because he just had it for lunch in California before he took off, that is acceptable encroachment. You should expect it. So because the reality of the world is that these locations are being placed in markets within your own quote unquote territory, some in fact have more, some have less. An argument franchisor will use is, look, the new store is generating more marketing dollars. So because we will be able to generate more marketing dollars, we'll be able to increase your sales by that amount due to marketing, which will offset the lost sales from our competing location. There's also another argument the franchisor will say is, hey, you want us to have more Firehouse Subs. You want us to have more, Dairy Queens, because you're increasing the value and goodwill of the brand. And therefore more people will recognize it. So people that live in the next county that were not aware of the fact that your business existed in this county are now being exposed to that brand and that product. And if they have a wonderful experience in the next county, then that's going to benefit you when that person who rides to work or that person goes to visit somebody in this county says, oh, wait a second. I remember going by, having a Firehouse Subs over in the neighboring county was great. I'm going to try it over here. Now, likewise, that imposes a different obligation on you. You got to make sure that that restaurant or store or hotel or business in the other county is being properly operated and maintained, and the quality is consistent and service is consistent and relationship with the customers is consistent as yours. Otherwise, that new location can bring you down without you having done anything. In addition to the encroachment, is just simply hurting the brand. So a lot of these, believe it or not, depends on the particular fact pattern and what the franchisor is doing with the new brand.
All right. Thank you. We have a bunch more questions.
I'll make them shorter.
Are you saying that if another franchisee is already in the process of building a store nearby, it's already too late to start the encroachment process? I guess they mean file a lawsuit or start.
It's every day that passes is a day later. I would do it immediately, because until the door opens up, you have the right to complain. Now, what I would do, and I won a big case on this issue within the last 2 years on this particular point, the franchisor, if you are in fact a good operator and you have the financial and operational resources and are in fact operating a business properly, you need to object and tell the franchisor you want that location for yourself. Now, you ideally don't want the location at all. And you say that to the franchisor, but say, look, if you're not going to stop it, then let me have it, because at least with my sharing of the G&A, the general and administrative expenses over both stores, the profitability of that store will help offset my loss of income in this store. And my ability to reduce my general and administrative expenses in my existing store by being able to divide the management support, let's say, or the marketing among these two stores will make my gross profit margin of my first store higher, which would therefore help offset the lost revenues that will counter that gross profit margin due to the second store. And that's a mathematics thing. That's why I tell you that my economics and accounting and finance background are utilized heavily in how I deal with these franchise cases on issues of encroachment, cannibalization, and anything that affects the bottom line.
All right. To what extent can a franchisor dictate hours of operation, no matter the negative impact those additional hours have on income?
It goes to the issue of good faith and commercial reasonableness. The franchisor, and there's cases on this point. For instance, if you have a franchisor that says you have to work till you have to be open till 2 o'clock in the morning or 12 o'clock at night, that may be okay if you're in a big city. If you're in Miami and you're in South Beach and a business is required to open till 2 o'clock in the morning or 5 o'clock in the morning, you may make a lot of money. But if you're in a small town in Oklahoma or Kansas or some other area where society there rolls up the sidewalks at 10 p.m. and you're being asked to open till 12 o'clock because that's a system-wide mandate, that is commercially unreasonable. And it's a breach of good faith, because I have seen many locations which have been open till 12, 1, 2 o'clock in the morning, and you have to have 3 employees. You have increase in insurance, because now you're running a late night operation. You have increase in theft and robbery possibilities. You have danger to your employees. And they sell 1 French fry, 2 Coca-Colas, 2 coffees. These are different stores, meaning one store may have, a Coke and a burger in 2 hours. Another one may have a donut, sold 1 donut and 1 coffee in 2 or 3 hours. Well, that is commercially unreasonable. And if you challenge that, I'm telling you, 9 out of 10 on those particular egregious sets of facts, okay, you have an extremely strong chance of winning. However, a lot of people just follow like sheep. They say, I gotta stay open, I stay open. No, if this presents a problem for you, if it goes contrary to the nature of the business, then you have to consider it. There's a lot of businesses that are, breakfast, lunch, dinners, breakfast, lunch, day parts only. They don't serve dinner. There's others that are lunch and dinner. There are others that are dinner only. And now all of a sudden the franchisor says, nope, now you got to do breakfast, lunch, and dinner. Well, wait a second. I got into the business because I wanted to sell this product during this particular line. And I'm not known for that. I have competition in my market for that. Franchisor just wants to impose the OPM doctrine, called the other people's money, which is utilized not only in terms of asking someone to renovate a store at a much higher level than is consistent with the price point of that store, or the same thing with a hotel, but it also applies in terms of hours of operation, where somebody's asking you to stay open much longer than is commercially feasible for the area. You can challenge those.
All right. Just search it. Okay. If the private equity company's exit plan is to IPO, wouldn't the decline in same-store sales from encroachment hurt the value of the franchisor in the stock market?
No, and I'll tell you why. Because what they do, you are one location in a particular market, and you're generating $1.4 million of sales. And your gross profit margin is 25% on those last dollars. And your net income on that 1.4 million is 300,000. They put another, the franchisor is getting its 6, 7, 8, let's say 10% because of marketing. Your franchisor is going to get its 10% of the $1.4 million paid to it, which is $140,000. You got me? Now, the franchisor opens up a nearby location. That location is going to eat into or cannibalize on yours. Your sales volume go down from $1.4 million to $1 million. But the new store is generating another $1 million because you split the market, but because of the additional location that is a mile or 2 away and the additional new customers that were not servicing that market before, you now have 2 $1 million stores instead of one $1.4 million store. Your gross profit margin goes down from 25% of $1.4 million to, let's say, 20% of $1 million. You're making 200,000 instead of 340,000. But the franchisor investors are getting 10%. Before it was on $1.4 million, but now they're getting 10% on 2 million. $1 million from you and $1 million from them. Wall Street would be delighted because now their income for the investor is higher, even though the income to the individual franchisee is lower. They care about top line system-wide gross revenues. That's why Wall Street will love them and not hate them.
All right. Next question. Are most brands acknowledging encroachment of delivery businesses since this data is new and difficult to capture, especially since delivery drivers are summoned from where the cars are located versus which store is the closest to the customer?
Franchisors will never acknowledge anything as having impacted the franchisee sales, because otherwise they would be accepting blame. However, they know the truth that in fact the delivery drivers and the delivery business is impacting franchisees. And because the delivery customer, they're going to argue, is someone who was previously not a customer at all. You see, we have a lot of people that now with COVID and everybody's now become afraid of the world to be out there and breathe our air because who knows what contaminant is in it. We're going to stay home, and that customer was no longer coming to us or never was coming to us. But now because there's delivery, we have now a new customer that never previously supported our brand. And therefore, delivery is increasing our revenues and increasing your business because that's to a customer that you did not previously serve. That's going to be their argument. In many instances, it is not true. You're simply getting delivery to your customers from other locations that you have nearby franchisees that are cross-boundary delivering to one particular customer. So that particular customer is going to say, well, who's got the fastest service, or who's the guy I like the most, or the woman I like the most? You know, those become difficult. But because of delivery, franchisors today, especially the big boys, the ones that have been around for a long time, the more mature systems, are not providing any protected territories. Simply, your location is only as good as the four corners of your building or your property, and that is it. We have the right to put a store across the street, literally across the street. That's what they're going to say. The problem is that it's so offensive that a court, and we had this happen to us in the Bryman versus El Pollo local case, I was able to win a decision from the court that said that that provision was shocking. It shocked the conscience of the court, the brazenness and overreaching element to be able to crush a franchisee. And based on the fact that our firm and our legal team was able to convince the court to find that that provision was unconscionable, was a stepping stone and a strong foundation for us ultimately winning the case, which at that time had a verdict of over $8.8 million, which with interest and everything was over, and attorney's fees over $12 million. But it was on that principle.
All right, I think we have time for two more questions. Is the franchisor required to disclose the cost of a remodel upfront?
That's a great question. Most upfront, meaning before the franchise agreement is signed or before the remodel is mandated?
Yeah, it doesn't specify.
I want to assume that it's very difficult for the franchisor to budget what a remodel is going to cost, because a remodel typically does not occur for 5 to 7 years or things like that. So I'm going to take this question as one where the franchisor rolls out a remodel. Typically, the franchisor has different packages for the remodel. There may be a complete scrape and build, meaning you tear down the whole building and you start again, and there is a budget for that. You can have what is a gut out, which is you keep the building, but you gut out the interior. Then you have a partial, which is remove all the kitchen equipment and dining furniture and replace that. Then there's a more serious level of remodeling, which is tear out the roof tiles, tear out the floor tiles, rip out the bathrooms, and change out the kitchen equipment and the sitting area, the furniture. And then there's another level that is include the outside of the building, parapets on the building, the color of the building, restucco the building, put new signage, change the landscape, repave the driveway. It becomes a block. The franchisor does have typically what the cost is for that level of remodel. What you as the franchisee need to do is ask, how much do you foresee and what is the budget for this particular level of remodeling that you're requiring me to do? The pivotal question, the most important question is, tell me what market research you have done. What test markets have you imposed or required the franchisee or the corporation to do this level of remodeling? And here's the question, what level of increased sales in the business did you experience comparing the before remodel to the after remodel? If they cannot provide you with evidence that that amount of remodel will give you a reasonable rate of return, which reflects that the increase in sales and income will serve to pay off the amount of the investment within the time before you have to remodel again, if they're not able to provide you that, I'm telling you, you don't have to do it. And no court will require you to do it unless the judge has no clue how to add, because it has to be commercially reasonable parameters. The return on investment has to, in fact, be consistent with you being able to get at least 5, 6, 7, 8% return over and above your investment. You got to be able to recoup all the money you put in and get a 5 or 6 or 7% in return on that money. If not, it is not commercially reasonable. But what happens is most franchisees don't know that. Most lawyers that do not have the financial background that we have know that, or even understand return on investment or present value or extrapolations or any of that stuff that goes into this whole analysis. And they don't even know how to argue it. And therefore, that's why a lot of franchisees get hurt when these impositions are made on them and they don't know how to ask the right question. I was able to, a few years ago, there was a blanket rollout of a major remodel of a major franchise brand. There was $300,000 per location. And I'm talking about 10 years ago. 300,000 10 years ago, ladies and gentlemen, that was a lot of money. And when the franchisee came to me and he had, several stores, for him it was like 10 stores, it was like $3 million. I said, relax, hold on. I sent a very pointed letter to the franchisor delineating the cost, the expenses, what we foresaw was going to be the impact on sales. And I said, unless you can demonstrate to me that in fact this remodel generates a return through increased sales that is reasonable to my client, we are not doing it. And not only did the franchisor not require us to do it, they canceled the whole program nationwide just because of my letter. So that means that they recognize that they're going to have to speak to a judge and say, Judge, I don't care what it costs them. They got to do it because my contract says that. Judge is going to say, nah, the implied covenant of good faith and fair dealing restricts that you can act in a manner that is unfair and deceptive and not dealing in good faith with your franchisee. And that's something that very few franchisees know. In fact, very few lawyers even know it. They tell the franchisee, oh, look, it says you have to remodel, you have to remodel. That's not true. The first point, where you start from the point of, okay, I have to remodel. That's what I would tell my client. Okay, it says here you have to remodel. Okay, let's start with that proposition. You have to remodel. I get it. But how much? To what extent? At what point do you go from crossing the line of being profitable, commercially reasonable to being commercially unreasonable. For instance, changing the kitchen equipment and updating it and changing the furniture may be reasonable. But then changing the floor and the tile floor, changing the roof tile, putting all this new signage makes it unreasonable. Maybe having to put these fancy trees in the landscape outside and the new lighting, security lights outside become prohibitively expensive. That's where you have to take a case-by-case basis.
All right. Last question. My franchisor built a company-owned oil change shop with a different name 1 mile from my franchised auto repair shop. They document the oil sales share of my shop at 65%. So it affects 65% of my affected sales. What should I do?
Complain, object. 65% is a very high percentage of sales arising out of the same service or product being sold that the franchisor has established a direct competitive business. I would like to know what state that's in. I would like to know what the statutes are in those particular states. But I could argue, and I also more importantly need to see what the language is in the franchise agreement, whether or not the franchisor has a reservation of rights clause, as I touched upon earlier, that permits the franchisor to do so. If the franchisor has a provision in that document that says franchisor reserves the right to build a directly competing business to that of the franchisee, selling the same type of product and service, but under a new name established by the franchisor, whenever the franchisor decides to do so, and the franchisee signed that provision, I would argue that it's shockingly unconscionable, but I can tell you there's a bunch of judges out there that would say, I am not here to rewrite contracts. The courts need to honor the sanctity of contracts. And Mr. X, why did you sign this provision in this contract? Why did you agree to that? Well, they wouldn't sell me the franchise unless I signed that. And why didn't you go to another franchise? It's not what is called an adhesion contract in law that you have no choice. You could have gone to another franchise, another oil company, another oil change company. You could have opened up your own oil change business without being tied to a franchisor. You signed a contract and you don't want me to enforce it. And in fact, you want me to rewrite it. Again, I think that the franchisee may have a case, but it's a lot weaker than if that clause did not exist.
All right. Okay, one more question because we've had this multiple times. What if the franchisor requires arbitration only? How does that affect your right to sue?
There's something called the Federal Arbitration Act. The Federal Arbitration Act says that if an agreement between the parties reflects that the parties have agreed to submit any disputes to binding arbitration to the exclusion of any other remedy, including lawsuits, those provisions are in fact enforceable. Now, and again, I don't want to start giving now a legal professor's explanation of that. There are limitations. There are exceptions. For instance, arbitration provisions take many forms. You have some where it simply says arbitration is required. Well, what does that mean? Who administers it? Is it the American Arbitration Association? Is it another arbitrator? Is it, JAMS? Is it different other companies that do private arbitrations? Who administers it? Number one. Number two, what is the timing of the arbitration? When does the arbitration have to be filed? You have to look at the statute of limitations in the contract, if there is one or there is not. If not, you have to look at the governing law in that state for statute of limitations under particular claims. Number three, how many arbitrators are there? Is there one arbitrator or three arbitrators? 3 arbitrators typically works as follows. Each party picks their own arbitrator, and the 2 together pick a third neutral arbitrator. What ends up happening is, the reality is the neutral arbitrator is the one that makes the ultimate decision, because each party appointed arbitrator is going to rule in favor of the client that pays them. So when you have that kind of situation, having a 3-party arbitration is not good. If you agree to a 3-party arbitration, make sure that each of the 3 parties arbitrators are neutral, meaning that the arbitration association and the other side and you all agree to 3 neutrals which do not represent the interests nor have the right to lobby the interests of any particular party. Then is the arbitration one governed by the rules of the American Arbitration Association, or do the federal rules of civil procedure apply? Or do the federal rules of evidence apply? That is in the arbitration clause in the contract. If it is there or it is not, there's more leeway. Most importantly, there are arbitration provisions that say that the arbitrator has to be someone who has over 10 years experience in the world of franchising and has worked for a company or has experience in dealing with matters that involve over 100 employees or 100 franchisees. Well, what happens there is that there are really no franchisee advocates, maybe except me and 1 or 2 other guys or ladies in the country that fit that criteria. Everybody else that fits the criteria is a franchisor sided person. So you've already lost before you started. So, and you also have, clearly as an arbitration provision, you have no jury rights because you're not in court. Plus you have the good privilege and honor to pay these arbitrators, which are acting as judges, their hourly fees. Their hourly fees to make decisions that a judge could make for you for free. And therefore, when these hourly fees on 3 arbitrators are $500 to $700 each, you're looking at $1,500 to $2,000 per hour for every time the arbitrators are reading something, or they are having a hearing, or they're going to have a trial. I've seen cases where the arbitrators' fees are $100,000. I've seen them where they're $300,000. I've seen them where they're $500,000. You need to try to stay away from signing arbitration provisions. There's also, you got to look at what is the scope of the arbitrator's ability. Is the scope of his arbitration provision that he handles all disputes that relate to the contract? And if it says all matters arising from the contract are subject to arbitration, then if you sue the franchisor for fraud or for misrepresentation or for negligence or some other business tort, it's called business dispute, then that claim is not arising out of the contract. So that could go to court while the contract claim goes to arbitration. Or you have to look where it says any issue or dispute arising out of the contract or the relationship between the parties, those words, or the relationship between the parties means that the business tort claims, the fraud, the misrepresentation, the negligence, is also subsumed into the arbitration. The problem with arbitration is that the original purpose of arbitration was the quick and efficient resolution of a dispute between the parties at low cost. The reality is it's become not quick, not efficient, very expensive, because many of these arbitrations are turning into full-blown trials. There's depositions, there's hearings, there's motions, there's rules of evidence, and then there's the trial. At which point you're paying 5 times what it costs to have a case in court. So arbitration provisions for everyone on this webinar, they are not good. In fact, the franchisors themselves have realized they're not good. What is good for the franchisor is that since they know that in any state in this country, you can file a lawsuit by getting yourself a lawyer. And if he's a contingency fee lawyer like I am, and my law firm is primarily, or with hybrid and creative fees as we do, then your entry, the key to the courthouse, is readily available. But if you have to pay hourly for the lawyers and hourly for the arbitration, then you have a different problem. If you have a law firm that does it on contingency or creative fee arrangements, they may handle the attorney's fees on a contingency, but not the cost of the arbitration. So the reason the arbitrators, the franchisors put these arbitrations provisions in there is because of the fact that the franchisors realize that the arbitration fees are a hurdle for franchisees to overcome, and therefore it protects the franchisor from the smaller franchisee who does not have the financial wherewithal to pursue the claim. So the arbitration provision, while you may be told, oh, this way we resolve the dispute quickly, is not true. Don't fall for that. It's designed to keep you from ever even initiating it because of the cost associated with the arbitration. And finally, arbitration provisions are final, non-appealable. In fact, it's so egregious that there are cases out there which say that the arbitration provision is not appealable, and even if the arbitrator does not follow the law, and even if the arbitrator gets the facts wrong. That's what the parties chose. Let this arbitrator decide whether he's got the law right or he's got the facts right. The only way that you can get an arbitration set aside is, one, if the arbitrator goes beyond the scope of the arbitrable issues in the arbitration clause, or two, you have evidence that the other side showed up to the arbitrator's house and turned over the key to a brand new Mercedes, or has a shopping bag full of cash, and then the decision came out against you. If you don't have that kind of situation, more likely than not, the arbitration provision will not be set aside for being unconscionable, or it denies you due process, the courts. No. The Federal Arbitration Act, Section 4, specifically says that our society wants the quick and efficient resolution. By the way, when that language was set up, it was not the type of arbitration that we're talking about today. Quick and efficient resolution, and therefore they are favored by the courts in order to reduce the clogging of the court system with a tremendous number of cases that they have.
All right. Well, I
Anybody
think
else?
wrap it up for us.
Okay, if you want another 5 minutes, I'm good. Whatever you want.
I think we're good on this end, and we have to wrap it up. But thank you, Robert. Do you have any closing remarks? Anything to say to everybody on the call?
You know, asking me if I have any final words.
That's true. I shouldn't have asked that.
I've
Yeah.
always got something to say. All I can say is thank you for those of you that listened to me today, not for listening, but for becoming more aware of what the issues are in the franchise, licensing, dealership world as it pertains to encroachment and cannibalization. And I thank you because I want you to be ambassadors to other franchisees. I want you to tell other people that they need to really think through these things, look at them carefully, make sure that they hire the right people in advance, early. Don't wait till the smoke becomes fire. Once you smell smoke, deal with it immediately. There are solutions. There are ways out. There are many times when the franchisor sees letters from our law firms and they just back down because they know it's going to be a war that they don't want to become involved in, because every time we win a case and we establish legal precedent, it hurts their ability to carry out their scheme to do whatever is selfishly motivating them to act that way. Be careful. Look out for private equity. Private equity has a goal and objective. Enter aggressively, pump and dump. pump the business with money, exit strategy, dump it while it's at its high, when there's a lot of locations, where there are a lot of projections and financial performance shown to investors, and then they sell them before the honeymoon period is over on all of these newly developed stores. If anybody has any questions with regard to any particular matter, my office is called Zarco, Einhorn, Salkowski, and Brito. I've been doing this longer than probably most anyone in the industry, except those that are older than me. But certainly in terms of quantity, I don't know anyone who comes close in terms of the amount of franchise cases and that they get hired to do and have represented franchisees for many systems as we do. We understand this. This is what we do. And any tangential issues that arise from that relationship, including problems with the landlord, leases, things of that sort, we handle anything and everything to do with franchising, from the moment you want to buy one to the moment you want to sell it, to the moment you need to litigate it. However, in our view, litigation is a last resort. We are avid, highly experienced, well-tuned trial lawyers. However, I do not initiate any lawsuit until I have tried every possible way, exhausted all available remedies to resolve the issue before getting into litigation. And the reason I do it is because it's important that the franchisee never second guess the decision to go forward, that they have to be committed and they have to have conviction. And secondly, I have to have conviction of going forward and filing a lawsuit, because I need to know that the case really warrants it, because I have tried everything else and the franchisor just doesn't get it. So you guys have a good week. My office number is 305-374-5418. But before you call, please look at our website, www.zarcolaw.com, so that you understand the vast level and amount of experience that we have before you call our law firm. Thank you so much, Sean. Thank you so much, Misty, and thank you all for attending this afternoon.
Thank you, Robert. Thank you for your time. Thank you for everybody on the webinar. Just want to send a reminder that CFA is hosting the CFA Day Forum on June 22nd in Washington, D.C. Please register now to talk about issues including unionization, labor shortage, tax issues, overtime regulations, and more. And I'm sure we will have Mr. Zarco joining us for our 2022 Legal Symposium. Stay tuned for that information. Thank you, Robert. Thank you, everybody on the call, and have a great day.
Misty, I plan to be there.
Thank you.